I'm joined now by former federal prosecutor Joyce Vance and David Priest, a former CIA officer who's briefed presidents and is the author of the President's Book of Secrets. Joyce, I begin with you, and I emphasize that there can be very controversial or problematically rendered rulings. They are law. Everyone, including the Justice Department and the prosecutors, the FBI, they have to follow it. And so I'm curious what you think happens practically in this case right now, as well as the criticism that, well, it seems like this judge is really going out of their way.
So it's not infrequent that litigants on one side of a case are disappointed in a federal judge's ruling. I think the disappointment here, frankly, is much more broadly based and goes to concerns about whether the ruling has any legal merit whatsoever. But that said, Ari, I think you make an important point that in a rule of law country, we're obligated to follow these rulings from federal judges. And if a party does not like them, then they have the option of going back to the judge to ask for a different ruling, which DOJ did here with its motion for a stay, and which the judge rejected. And now DOJ can go to Atlanta and ask for a ruling. There's been a lot of criticism about that court as being composed of six of the judges on that court, which has 12 seats. One is currently open, so there are only 11 judges, but 6 of them were appointed by Trump. But, you know, every federal judge has to be appointed by one president or another. While this has been characterized as a conservative court, it is perhaps conservative in the sense that it has often spoken in favor of the rule of law. So what we'll find out now is whether the 11th Circuit will continue to honor its proud tradition and join the judges, many of them Trump appointed, who after 2020 resoundingly said that there was not fraud involved in the election and ruled against the former president because it was the right thing to do on the facts and the law.
Yeah, understood. And David, as we learn more about why Donald Trump kept these materials at the Florida compound and who lied about them, it definitely looks worse. I've told viewers of all the assorted cases that involve Donald Trump, I do not believe, based on the current evidence, this is the one that's most likely to involve, for example, his personal indictment. And there are a lot of reasons for that, including the layers of people around him. That doesn't mean no one would ever be indicted. It doesn't mean that people misfired if they thought they could just lie to the government or prosecutors and get away with it. So given your expertise on intel, let's read a little more from the piece I mentioned in the Post that the White House counsel said he did talk to Meadows, the former chief of staff, who made the assertion, because they knew there were dozens of boxes. So you can't just say there's nothing there. And he said, quote, the people familiar with the call say that he basically said these clippings were not intelligence. Trump's team was aware of no other materials, the lawyer says, relaying information he got from Meadows. So what does it mean to you to claim that it's all news clippings? Does it sound like something that Mr. Meadows could have been completely confused about, or does it sound like a cover-up that could turn into a crime?
Well, you've got to have the investigation to examine a couple of different steps there. First, you've got to have the step of who told Mark Meadows that, or how did Mark Meadows get that impression? Was it directly from the president, or was it his own belief because he had some access to these documents? So that's number one. Then another one. You look at Pat Philbin and Mark Meadows and the chain there. Philbin says that Mark Meadows told him this. What actually happened there? And the problem is right now, the government, following the order from Judge Cannon, they're not doing a full investigation. Sure, the judge said they could go ahead and do some steps of the investigation, but they couldn't use the content of these documents to do it. Well, that's awfully awkward. That's like interviewing a witness and saying, when did you see that document? And they say, what document? And then you have to stop because you can't describe the document except, oh, it's one of those with a top secret cover sheet, or it's another one. You can't point out what the actual title of the classified document was because the judge is prohibiting the government from doing that right now.
And that brings us full circle back to Joyce. I got to say, maybe the beat bookers picked the right guess because we have both lanes covered. When you get back to the legal part, Joyce, does it really make sense for a judge to be micromanaging an open probe of this nature? If you weren't a lawyer, you'd wonder why the person who had their home searched for stolen materials that aren't theirs is now getting this deference as compared to the prosecutors who are dealing with the contraband. I mean, now they have a limit on using stuff that, best we know, and I will always update on our broadcast if we learn something different, best we know, ain't the search subject's property to begin with.
This is a very unusual form of interference by a district judge into the government's ability to investigate a case. DOJ executed, as you and I discussed ad nauseum, Ari, a search warrant that was issued by a federal judge who found that there was probable cause for the government to proceed. And DOJ was very clearly entitled to the stay that it asked the judge to issue in this case, because really the fight is not about everything that the government found during this lawful search, although it could have been and may well end up being in Atlanta. It's just about documents that bear classified markings, documents that are presumptively classified. And yet this judge has bent over backwards to credit an argument that even Trump's lawyers failed to make. Because while in the course of briefing here, they argued that Trump had the authority while he was president to declassify documents, they never said that he had done that. And one suspects that they didn't go that far because they were filing papers with the court and they had an obligation to be truthful. And so they stopped short of telling a lie. Now we have a federal judge, though, who seems to be insinuating that there's a possibility that the former president did declassify the documents. That's really the only basis that would support her ruling. She is so far out ahead of where the evidence is in this case that it is simply an unmerited interference in the criminal justice system. It does not serve Americans. It does not serve the rule of law. Hopefully the judges in Atlanta will have an opportunity to remedy that wrong.
And to what Joyce is referencing, David, I'll read that part of the ruling. The judge refers to the premise that these documents are classified government records and then says the judges refer to themselves as the court. So she says, the court doesn't find it appropriate to accept the government conclusions on these disputed issues without third-party review. Again, the review will take time, but sooner or later it'll end. But, David, the review here would be what? That not only the special master makes sure there were no errors, like, a wrong piece of paper got in a pile, but that what? There's some secret forgery that it says classified on there, but it's not classified? I mean, in what world would these classified documents that have gone through the process, that a magistrate oversaw, that the Justice Department decided to search at the highest levels of Merrick Garland, would then turn out to be not classified at all?
The only scenarios I can think of where that could happen is if the special master found out that the FBI investigators had been either completely incompetent or completely evil, or both. Because the only reasonable scenario of looking at a classified document that has classification markings on it is that somehow in this mess of papers and other materials that the former president had stored in each box, that some other piece of paper slipped in, maybe got half stuck under a staple, and that page wasn't classified. But then that assumes that the investigators, in flipping through these documents, and we know they did so because we have reporting that some of them had to get additional clearances in order to look at some of these documents, that they didn't notice that there was a personal note or a sock or a hamburger wrapper, whatever it was, stuck in this classified document, and they're pretending that that's classified. Short of that, it's pretty easy for this special master, who has years of experience on the FISA court, who has been around classified material a lot. It's going to be a pretty quick operation for him to look at these classified documents, flip through them, and determine, yeah, they're no kidding classified. There's nothing in here that was obviously misclassified or something that the government is representing as classified that is not marked as such. That part should be relatively quick and easy if it gets to that point.
Gotcha. Really interesting stuff. David and Joyce, thanks to both of you.